Answer.
Mr Speaker.
The Honourable Jerry Brownlee.
Mr Speaker, I seek leave for the Hurunui Kaikōura Earthquake Recovery Bill to be now read a first time and referred to the Local Government and Environment Select Committee for consideration, and for the bill to be reported to the House by the 6th of December 2016, and that the committee have the authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day on which there's been a sitting of the House, and on a Friday and a week in which there has been a sitting of the House, despite Standing Order 191 and 194, 1B and C. Mr Speaker, I seek this leave as opposed to a motion because the bill is well known to the House and will be considered at a select committee for a short time.
I need to put the leave. Leave is sought for that course of action. Is there any objection to that course of action being followed? There is none. I understand it is the intention of the government to introduce the bill.
Earthquakes Recovery Bill, introduction.
The bill is set down for first reading forthwith.
Mr Speaker.
Honourable Jerry Brownlee.
Mr Speaker, the Hurunui Kaikōura Earthquake Bill, or I move that the Hurunui Kaikōura Earthquake Bill be now read a first time. Mr Speaker, as I said in the leave motion, we nominate the Local Government Environment Select Committee to consider the bill and for the bill to be reported to the House by the 6th of December 2016. Mr Speaker, that committee will have authority to meet broadly during the short period that they've got to consider the bill. Mr Speaker, the earthquakes of the 14th of November have left a very indelible mark on communities throughout the upper part of the South Island and in parts of Wellington. And it's impossible to fully understand what might be needed to recover from those events. This week, with unanimous support across the House, we've passed legislation that will significantly help in that earthquake recovery. But that alone is not enough. We know that with such a big earthquake and the subsequent aftershocks, the widespread destruction that comes with that will mean that it could be a considerable time before all of the damage is understood, and more importantly, the consequences of that damage is understood in relation to communities' recovery. Mr Speaker, like the Canterbury earthquakes, the true scale of it will take some time to determine. As I said in the House earlier this week, I acknowledge the many civil defence personnel, engineers and defence personnel who've worked hard to assist those affected. I'd also like to compliment those people who work for the many contractors who are now engaged in keeping roads open, and particularly their families who will be experiencing their long working hours by their absence. And Mr Speaker, in order to keep that effort going, there may well be a need from time to time to suspend, amend or change some laws that relate to that recovery. This bill sets out a proposal that would allow a specified list of legislation to be amended by Order in Council for the earthquake-affected areas where necessary or desirable for recovery. It's a flexible mechanism that allows us to react quickly to a range of issues. The issues that may need to be dealt with are not yet fully understood, and I state that for the record for the third time to make it very clear that in passing this bill, the Parliament will be enabling those works to get done in a speedy fashion. Mr Speaker, we are coming into the Christmas New Year period, and it is possible that there could be an aftershock that might have an effect on one of those roads, even if there had been good progress made on them. It's important that momentum is not lost. Mr Speaker, I recognise that these are extraordinary powers, and I appreciate that there will be concerns about using Orders in Council mechanisms, as was the case in the Canterbury legislation. Appropriate constraints are therefore quite important. For that reason, there are a number of limits and controls on the exercise of the Order in Council power in the bill. The order must be necessary or desirable for the purpose or response or recovery from the earthquakes and must be no broader than necessary. The bill only applies to those areas directly or indirectly affected by the earthquakes. This includes alternative roading outside the main affected regions, for instance, Nelson West Coast, which now hosts a main road from Blenheim to Christchurch and route south. Mr Speaker, some of those roads have experienced no more than 100 traffic movements a day, but are now experiencing up to 700 truck and trailer units per day. Quite a different prospect, and it does raise issues of safety that will have to be addressed. But it will, sir, have to be done so responsibly and without any opportunistic behaviour. Mr Speaker, the provisions of this bill are time-bound. The ability to make orders and any orders made under this bill's powers would both expire in mid-2018. In other words, it's not an opening up of law on a permanent basis. It once again is restricted to the activities needed for immediate recovery. An independent review panel will advise on draft orders, and the relevant minister must have regard to their recommendations. The panel will comprise of iwi and local government representation as well as legal expertise. There are also certain fundamental rights and obligations that cannot be subject to the bill's Order in Council process. For example, the Bill of Rights, the Electoral Act, and the Electoral Act cannot be amended. Draft orders will be provided to the Regulations Review Committee or to leaders of political parties during a recess for comment, and the relevant minister must have regard to any comments received. The order, once made, will be subject to the House's normal disallowance provisions. Orders can only be made in respect of the specified listed acts, which we think may need to be amended or to assist recovery. That list of acts is something the Select Committee will, I'm sure, want to closely scrutinise. It is obviously no small thing to change primary legislation without primary scrutiny. The Regulations Review Committee process is to provide some of that scrutiny without unduly delaying the changes that are necessary to assist in the recovery. The Order in Council process was successful in assisting recovery in Greater Christchurch. It's designed to be flexible to deal with a range of potential matters, including temporary housing, accommodation supplements, streamlined planning and consenting processes, geotechnical assessment, and tax and financial reporting deadlines. No one should read into the list I've just given an exhaustive list. There will be things that come up from time to time that this legislation will enable, will facilitate being dealt with. Mr Speaker, it's not a central government takeover either. I expect ministers to engage with local councils and iwi in developing proposed orders. The requirement in the bill in relation to the review panel also formalises local and iwi input. Mr Speaker, the bill facilitates recovery without needing to anticipate every power or statutory provision that may need to be amended or to assist with recovery. It's worth noting that it will be, if this bill passes, the will of the House that this mechanism is available to achieve those things. And no one should read into the intention of the House anything less than that. Mr Speaker, I think there are robust limits in this bill and appropriate controls because it is necessary and expected by people who put a sovereign government into place that they will do something. And this, sir, over the last week has been an exercise on behalf of the House that the Parliament of New Zealand wants to do something to help people in Kaikōura. I look forward to the comments in this debate. I look forward to the discussion that will go on in the very short Select Committee process and commend the bill to the House.
Members, the question is that the motion be agreed to.